Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
Welcome to another episode of Just Verdicts. Today, psyched to talk to my longtime friend, Sandra Neuman. And before we jump into the story of Sandy and an awesome verdict that she got recently right here in Allegheny County, just want to give a quick shout out to LawPods, who produces the show and makes this happen, makes my life easier to create and record these podcasts. They produce everything. So if you are one of the 2 or 3 listeners to this podcast and you're interested in doing your own, consider reaching out to Rob Ingalls at LawPods. Highly recommend them. With no further ado, Sandra Neuman. How you doing, Sandy?
Doing great, Brendan. How are you?
I'm good. I, as I alluded to, I'm so psyched to have you on because I'm in the 20s now of recordings at this point, which surprises myself. And I'm thinking back, and you are one of the first people who is, genuinely one of my close friends for a long, long time. Part of our little, reptile / edge group / whatever it's been for a long time. And it's just awesome to get to talk to one of my close friends about an awesome verdict. So I'm really happy that you're here and that we get to talk about this.
Well, thanks for having me.
Yeah. It's awesome. So I like to talk and sort of start by, transporting you back to law school. I think about, what I was like in law school and, how I've changed over time. And we didn't know each other in law school, but, if you go back those many years, can you kind of walk us through, where you were in life at that point in time? Why'd you go to law school? And then once you're in it, what are you imagining where you're headed at that point? And then kind of walk us through, like, how do you get to now, being the founder of Sandra Neuman Law and, obtaining so many awesome settlements, having an amazing reputation, getting this great verdict, what's the journey?
Well, I always wanted to be an advocate, I think, like a helper. It's kind of been the way I was raised. And I did not think I would be a trial lawyer, to tell you the truth. I was kind of like a writing nerd in law school, and I had a different ambition. I thought that maybe I would get into appellate law, or I thought like representing women and children. So I was an articles editor at during law school, and I was part of the appellate moot court competition. So I thought like appellate work was kind of where I wanted to go, and I had a law clerkship with Judge Hudock, who offered me a job. But before the job was to start, I had like a little bit of a gap to fill. And a friend of mine was a law clerk at a trial court, and she said, "Hey, there's an opening. Why don't you try to plug yourself in before I start my Superior Court job?" And I did that, and then that's where I was like, oh, wait a minute. Trial work is kind of, interesting. There's a lot of different things you can do. And there were a couple of very dynamic attorneys that I saw, and I was like, maybe I could do this. I don't know. But I went and I did my clerkship at the Superior Court. And then through organizations like Western Pat Law, I had met a phenomenal female trial lawyer who is now a trial judge, Beth Lazera. And she said, look, you need to get to Pittsburgh. At that time, she was working for John Gismondi. And she said, you need to try to get down here and get into, trying cases. So I did. I went and started working at Gismondi and Associates, and, phenomenal trial attorneys there. And from there, I basically had my career at 2 different firms, both of which were, heavy medical malpractice firms. And that's sort of where I settled. And I love it, yeah.
That's awesome. So that's, I always like the transition from, had no expectation of becoming a trial lawyer and then, something about this process kind of sparks an interest in you and you go down this whole different path in life. Do you remember, any of the attorneys or the cases in particular when you were in that trial court that kind of, I mean, was it criminal? Was it civil? Was it both
Everything.
that kind of made you think,
Yeah, so Butler County, the judge, there aren't specialized judges, or there weren't at that time. So it was, everything that came before my judge. And this, any of them, they were like really spectacular. Rich Goldinger was like a district attorney at that time, really good guy. Tom King, who was a civil trial attorney. I actually worked at their firm for a little bit. Just inspiring, like great court presence, and people would just come from anywhere to try cases, and there was something about that that just attracted me to wanting to be at the trial court level, and the wide variety of issues that you could encounter. I think I had been prepared through the Superior Court clerkship, and I thought, like, being in a trial court was something that was where I could see myself.
I think there's nothing quite like actually sitting in a trial to, get that sense of things. I mean, we can talk about it all we want, talk to others and so forth. And even I think if you watch on like CVN or something, you get the sense of it. But when you're actually, in that courtroom when a case is going on, sort of regardless of the stakes, as long as it's important to one or both sides, there's just something about it, I think, that's very electric, despite the fact it can be wickedly boring too, a lot of the time.
Right. And it's, when just watching it is, I agree, it can be very exciting. It can also, you see like, well, if this person can do it, and like, boy, I think I could do better than they could. It gives you confidence, and also gives you something to aspire to. I mean, it's phenomenal. I don't know. And when you're doing it, you talk about electric. Yeah. Like it's, yeah.
Well, we hope.
Yeah.
I
Right.
hope I'm being
Right. I don't know.
electric. I just wrote an article about that feeling when you think you're crushing an exam or you're closing argument. You look over and there's a juror like pulling up their sleeve to look at their watch. Like, hurry it up, buddy.
Right.
But so I want to dig in a little bit about John Gismondi's office. So Judge now Judge Lazera recruits you to start there, and so many great attorneys presently and in the past have come through John's office. So talk to me briefly about how did you get introduced to trying cases? So I mean, what kind of cases did you first be put in charge of, and then how did you kind of evolve from there before moving on eventually?
Oh, so like literally like John was like feet to the fire. You're here. Okay, here's you're gonna try. It was a death case, radiology case. I'd never tried a case on my own, period, let alone something that was, a technical medical issue. And, John's a great teacher, but it was kind of like, you want to be a trial lawyer, here you go. And I believe that's, how he was baptized in the, trial law. Like, go do what you think you want to do. And at his firm, we didn't try cases together. Typically, I think maybe once or twice I tried a case with John, but it was, here you go. And it was pretty quick into being hired that I tried a case. And, interesting. I've lost, I think we talked about this, Brendan. When you try a lot of cases, you lose a lot of cases statistically, period. And John would say, well, it builds character. Like, it's not you, like, hang in there. You're a good trial lawyer. It's going to be okay. But it was quick. It was within the first few weeks, I want to say, or first couple of months, I tried a death case. And then it was, I probably 8 to 10 or 12 cases I tried through his office.
So I am biased toward the, trial by fire, baptism by fire, whatever you want to call it, way of getting experience, because you could debate this. Oh, you should, kind of slowly progress people and so forth. But, I think it said a lot about you that you were, because the reality is, and I'm not trying to, puff you up or anybody else, unnecessarily, but the truth is a huge percentage of the population would have freaked out at being handed a case to go try like that under those circumstances, and either not have done it or suffered through it and then said to themselves, like, I don't ever want to go through that again. So I think that there's something really telling, in addition to everything that you learn, the experience that you gain, and what John said, that it will build character. I mean, that reminds me, and I don't know if you said this to your kids, and I want to talk about, what else you have going on in life in a second, but I mean, I just remember growing up and just, my mom just making me do all sorts of things I didn't want to do and just getting beat down left and right. And she was always like, it's character building, it's character building. And then, you get to a point, you're like, how much more character do I need at this point? But I think personally, for trying cases, if people want to become a trial lawyer, that is the way to do it. Just get in there, and it's kind of sink or swim, and you're going to know if this is really something that you want to do. Do you have that calling or not?
Right. And I learned really quickly there's a lot of stuff I didn't know, but you have to be able to think on your feet and take care of it. I mean, that first case, it was a percutaneous transhepatic cholangiogram that had gone wrong, and I couldn't even pronounce.
Easy peasy.
Right. And so, God bless Dawn Carson, who still is the PA there. She would, work with me and teach me the medicine, and that we went down to the last witness. Bernie Rizza had called his doctor, had him say something that had been subject to a motion in limine, and it was a mistrial. And so I had to try the case all over again, 2 weeks later, and got better the second time. But I agree with you, trial by fire, there's nothing like it, but you do learn what you don't know, which at that point I didn't know a lot of things and still probably learning,
how else? Yeah, but how else do you learn? I mean, I think there's no way to, speed up or accelerate the learning process than by going and trying cases. I mean, you instantaneously in the moment are learning so much of oh, okay, this in my mind seemed like a good idea, but I would never do this again. I'm boring this jury.
Right.
This doesn't work, or this did work. Somebody actually perked up, and that kind of stuff. But we can read all the books, we can talk all we want about different stuff, but actually getting in there and trying cases is there's nothing compared to it.
Great.
So I still want to move forward in your career because it ties into so many, people that I'm fond of. But I want to put in context, one of the many things I think is amazing about you, which is, you have done all this while being a mom of 3 daughters, being a wife, and there's no doubt, your husband is carrying, his fair share as well. But I mean, you're doing all of that and running a practice and, being, a highly respected, great reputation trial lawyer. I mean, I don't do that. So I guess in a sense, how do you do it? How have you done it over the years?
First of all, that's not true. You had 3 kids in the same sort of time frame that I did. How I did it, by the grace of God, and been super blessed with my mom and my mother-in-law to help when I would be working. When I had my first child, I was working with John, and I went, part-time, which it was wonderful. And I didn't go back full-time until my youngest was in kindergarten, but I continued to try cases. And so that part-time schedule would be put on hold if I had a trial. And I had, a husband who had he does have a flexible job. He's in pharmaceuticals. And we just made it work because, being a mother is the most important job that I have. And, but I love, and my kids have come to know my clients. And when I wasn't there, they would know, Mom is helping so-and-so, and here's what would happen to this person, and she's trying to make a difference in their life. So I always, when my kids were of the age to understand, they knew where I was if I wasn't at home, because what a trial schedule is like. I wouldn't see them for, a week or 10 days, or if I did see them, it was when they were sleeping. And, you find ways to stay connected during that time, but I tried to raise them to see, like, you, not that you can do it all and have it all, because I think that sets you up for a lot of disappointment, but that you can make it work, with good communication and, prioritizing what's in front of you, and with a desire to, be good as a parent, and, really represent and try to do what's right and get justice for your clients. I think they're both very noble callings. And, believe me, I've probably failed a lot more times than I'd like to admit in juggling those rules, but both of them are very important and still are. Like, you don't stop, worrying or being involved in your kids' lives when they're young adults. I mean, it's just a whole just different level of worry.
I think too, as long as, when you're there, you're present and you're accessible to your kids, and, they know that you love them, just endlessly, and that everything you're doing in large part is for them. There's a big upside too of leading by example, that, your kids know that, mom is out there, working hard in a noble way. And that in and of itself is just a great example for them, that you're going to imprint on your children that, this is a good way to go about life, working hard, providing for, while at the same time, trying to improve yourself, be the best parent that you can. I think that's a wonderful way, to raise a family. So I want to pivot now briefly to, when you and I mean, it's been a long time that we've known each other now, but, I first got to know you when you were with Veronica Richards. So talk to me how you went from, Gismondi's office over to Vonnie's office, and then, and now you're out on your own at Sandra Neuman Law.
Right. So I met Vonnie, and I knew that she had an associate, but she was remote, and she was looking, for some extra help. And we had met a couple of times while I was still at, Gismondi Associates, and talked, and we thought that we would be a good fit. And it, after I had my third child, the geographic location of where Vonnie was located, it was like pivotal between like where my kids were in school. And I just really was excited about, Vonnie's background and her dedication. Like, we sort of had the same philosophy on why we did what we did. And, she has a stellar reputation. And when she, said, "Hey, I'd be interested if you wanted to, come over," I of course was. And it was, tough decision for me to, decide, do I leave, an excellent firm and go with her. And I did, and I, don't regret it. Like, it's phenomenal. Like, it's different. It was different in that we did all of our cases, tried all of our cases together and divided it. Her medical background was huge, and just from a learning perspective for me. But we shared the same philosophy about, taking care of our clients. And so it was a great opportunity. And, we had a really, really good, I don't know, 15, 16, whatever it was, years together, phenomenal successes, doing a lot of great things for a lot of great people.
I'll say, in the Commonwealth of Pennsylvania, you were fortunate enough to have probably, two of the best, mentor type people to work with over the course of your career coming up as a trial lawyer. So I'm envious in that regard, because I have great respect for John and certainly Vonnie. So let's pivot now to what we're about here at Just Verdicts, which is talking about, this amazing verdict that you got a couple months ago, or maybe it was a month and a half ago. And, I love the setup to this too, in that, putting it in context, you've gone out and, hung your shingle as Sandra Neuman Law now, and as a fellow, small firm owner. That is scary and risky, and, you're having sleepless nights for a variety of reasons and so forth. And here, now the defense is forcing you to go to trial, and you get this great outcome in the course of it. And that, among other things, that it happened to you. I know you worked so hard, but it happened to you at this point where you are with your firm made me really happy when I heard that the jury came back for you that way. So
Thank you.
so we're here to talk about of course, the Rotz versus UPMC or UPMC Passavant case. So why don't you give us a little summary of what this case was in a nutshell, and then I want to talk about sort of the discovery aspects of things that teed this case up for trial.
Sure. So I knew Michael. We share a godchild together. So we had been at social situations together for, 20 years. And he called and told me that when he was admitted, he was going into the hospital for a hip replacement, and he had very low sodium, hyponatremia, and they had to postpone his surgery with the goal of getting his sodium up and then doing the surgery in a day or two. And he was supposed to have bathroom assistance, and he fell, and he had a really nasty fracture of his dominant arm. And, so I said to him at that time, I'm like, look, Michael, definitely, I'll look into it for you. This is something that they should want to settle if they violated their policy. I'll help you out, even though it wasn't like a traditional mold of like a catastrophic damage. It was something that I felt like, hey, I'll try to work something out for you, help you out. And then his injury progressively got worse. But we, looked into the case. We signed up the case, got the records and saw, in my mind, I was like, this is a slam dunk on liability. Let's just see and this was right in the COVID era. Let's just see what happens with the injury, and we can get an assessment of what it's worth. And then, let's try to get the case resolved. And for whatever reason, it didn't. And we had to try the case. Like they did not make a fair offer. And I've always said, like, I'm not going to undersettle or undersell my clients. It's their call. And he really relied on what I thought the case was worth. And you kind of get forced into either getting the reputation of undersettling or getting the reputation of, if you're not going to pay what's fair, I'll try the case. And we've always said, we'll try the case. So that's what we did.
What was it about when you first looked at the case, got the records after Michael, and I'm assuming it's Michael Rotz,
Yes.
your client in the case. So you get the records. What was it that jumped out to you that you felt that it was a strong liability case?
Okay, so he was a level 2 fall risk, the highest fall risk that they have at UPMC, and he was ordered to have bathroom assistance. And if you looked at his PT and OT assessments, because I was thinking, well, they're going to say, like, we told him to, that how they had it documented in the record was that he was escorted in and did not pull the call bell, which he said that he did, and that he fell. But if you looked at how they described him, like, first of all, somebody with a critically low sodium is going to be dizzy, is going to have some confusion. That was all documented. But what I thought was really strong for him, to the extent that they were going to try to blame it on him, which of course they always do, is that they clearly charted he had impaired safety awareness, like impaired judgment. He couldn't be, he couldn't follow commands or like follow through. And so I just felt that, they knew that they should have been with him. He's saying that they left him alone. They're documenting that he's confused and impaired safety awareness. And so I just felt like, what could they possibly say to that?
And so in reading and talking to you previously about the case, so the gist of it is essentially he's admitted at Passavant. He can't have the planned procedure right away because of the low sodium, right?
Right. And the planned procedure is a total hip replacement because of how he can't walk. So like and he has arthritis everywhere. So he didn't just have one bad hip. They were operating on the worst hip. He had the other hip was also bad. He had bad knees. So he was really hampered from a mobility standpoint. And then you add the hyponatremia on top of that. He needed somebody to be with him.
And from a notice and foreseeability perspective, UPMC, properly labels him as the highest fall risk level 2. And as a result, when he's doing things like, hey, I need to use the bathroom, he's required to have some degree of assistance in getting there and getting on and off the toilet. Is that pretty much what they require?
Yes, right. So their policy is it does not define bathroom assistance, but best practice and standard of care, according to the corporate designee, is arm's length. And he definitely was not, there was nobody within arm's length of him. And this is what came out through discovery. And we can talk a little bit about the things that they tried to prevent me from getting, but definitely it's arm's length. Like, you don't have to stand on top of a person. You can have the dignity of the patient and try to give them some privacy, but you've got to be able to see them and you've got to be able to get to them if there's an issue. And that didn't occur.
And what happened here? Yeah, what
So
happened in this
he
case?
was had a 2-person escort into the restroom and said to them, "Listen, I'll only be like 30 seconds. Like, you can just wait." And they said they'll be right outside the door. They put him on the toilet, and the door is open a crack, but there's nobody there. And they said, "Pull the call bell when you're done." Now, what's interesting is the call bell flashes in the hallway, like outside of not the bathroom door, but the main door. And that became like an interesting point during trial, pull the call bell. And he did that.
Does it literally make a
It
sound
makes a
too?
sound and it lights up in the hallway. So Michael said he did that twice, and that the bathroom is literally like very compact. He could push the door open while still sitting, and said he called out and was like, "Hello, I'm done. Like, help me." And nobody came, and he could hear, it was a male and a female that had escorted him, and he could hear them like talking and laughing. So he thought maybe they were at the door of the room, and he got like braced himself on the door frame and like leaned out to like yell like, "Hey, I'm done," or, "I'm ready to go back to bed." And he, stumbled and fell, and that's what happened. Nobody was at the door. They weren't not in the room, according to Michael. And after he fell and cried out, like, 2 of them came in from the hall.
So he's supposed to, have somebody right there, arm's distance. They're not there. He pulls the bell. Nobody comes. Now he's trying to. I mean, he's kind of stuck, right? I mean, he's calling for help, and then in the process of trying to call, falls, shatters his wrist.
Correct.
So so that's Michael's story.
That's Michael's.
So what was UPMC's version of what happened, and why, there was this disagreement that took you to trial?
So they document that he did not pull the call bell, but nobody had asked him or interviewed him what happened. And the medical record itself was just that he had been escorted in and did not pull the call bell. That's really the bare bones of the medical record, other than the things I had mentioned about the impaired safety and all those other issues. I had requested policies. I'd requested an incident report, any type of emails anything about the event, and they refused to give them to me. And they were like, "This is peer review protected." I mean, come on, incident reports in Pennsylvania are discoverable. I mean, everything was like a battle to get the documentation. And I had to file at least 3 or 4 motions. And that's one of the takeaways. I think a lot of times we don't push because it's, time consuming, and it's, well, we think we have a good enough set of facts and we don't need it. But I discovered that there wasn't just one incident report, there were two, not prepared as per policy, but miraculously, the second incident report took some exculpatory language out that he had been left unattended. And so I first was given the double incident reports, and then later had to file another motion to get the email that the patient care technician had prepared, which also said that he and the nurse left the room. So I felt after getting those documents and then deposing the people involved that there was, no way they were going to try this case. I mean, it was absolutely clear that they violated their policy.
Because by admitting in the email that they weren't there, I mean, that was a direct violation of what was required under UPMC's policy for Michael.
Correct. Right. So there were two nurses involved, like the charge nurse who had documented his fall risk and was aware of his condition that necessitated an assist in the bathroom. She testified, and I nailed down, first of all, nobody, of course, has a memory of anything. But she said he required somebody in the bathroom with him, arm's length. I would have been in the bathroom with him. That's the charge nurse. A nurse had answered the call bell in question. She was an administrative nurse on duty. She said, I didn't know anything about him. That's why I called the patient care tech. But I'll tell you, if he's a level 2 fall risk requiring bathroom assistance, he never should have been left alone. That was her testimony. And then the patient care tech, whose email I got very late in the game, by the way, after his deposition, he, we can talk about his testimony, but he knew nothing. He remembered nothing. He couldn't remember what his training was. He couldn't remember anything. But his email said he had been left alone. So I'm like, all three people are going to be rock stars for me. And I just thought, well, again, this case is it's going to settle. We'll, take care of him through settlement, and didn't happen.
And why, I mean, from a strategy or viewpoint perspective, if you were to guess why, with all that evidence, you've taken these depositions, you've locked these people in, then you get these really helpful incident reports and an email that completely make out your case. Why do you think, or what was the take on the other side for why this case still tried?
I think, when people hear, well, you're going to go to a jury over an arm fracture, like it's an arm fracture, they're not going to value it the way that I thought that it should be valued. I mean, the adjuster for UPMC said as much. It's an arm fracture. I also think that, there was an issue of medical records that they had obtained, not through authorizations by my client, but, subsequent hospitalizations that they might have thought that, due to Michael's health or other situation, that he would undersettle or he would take an offer. And, but I don't know that. I know that we just disagreed about the value of the case, and that's not shocking, and that's when you decide, are we going to take this crappy number, or are we going to try the case? And I think they just thought a jury was not going to be overly generous with what they would say is it's just an arm fracture. Of course, my position was it was way more than that, but
Well, and to be fair to the UPMC decision makers and complimentary of yourself, there were no economic damage claims in this case, right?
Correct. And there was a strategic reason for that, because Michael was a finance manager at a very large auto company, but he had stopped working before this fracture because of his orthopedic injuries. And he did intend to get back into the workforce, but he had other medical issues that really prevented that. And I didn't want to look like a stretch to say that the only reason, and I didn't then want to have to like decipher what percentage of his ability to go back, not go back to work is really, you know what I mean? So we made a decision that we weren't going to pursue an economic claim, which I think was the right decision. And no, this was a purely no, purely non-economic damage case. We didn't put the medicals in on purpose for fear of anchoring the lien. It was just all pain and suffering.
And all pain and suffering cases in Pennsylvania are, tougher than in most other states because
Right.
we
Can't ask.
cannot
Yeah.
ask for specific number. So there's that whole concern. What is this jury at the end of the day going to think this is worth? And, how can I even begin to get them to think about what would be fair value here? And we're going to talk about, what you did in that regard. But let's jump to, that moment when, you and Michael know you guys are headed to trial. This case is trying. Walk me through sort of your approach to, how are you going to tell this story? And specifically, in a scenario like this, you could, on the one hand, kind of blame these individual representatives. Oh, you made a mistake, individual. Or to me, there's also clearly a systems case here. I mean, there's this, and probably more to it than just the policy. Can you talk about like how you were thinking about how you're going to frame this case for the jury?
Sure. So I knew from my discovery and my depositions that their witnesses were going to be my witnesses. I was going to make them, make my case. And I also understood and did not disagree with the defense that this is, what it comes down to is he had a single injury. And so, how much time did I want to take of the juries to tell my story? And through our group and through talking to you and a couple of other people, like the concept of speed trial was like, hey, I'm gonna get in there. I want my case done in less than 2 days. And that's what I did. It was a day and a half, if that, because it's not complicated. Like this was the easiest medical malpractice case that I've ever had in 30 whatever years. It'll probably be in the history of my career. Like this is not hard. It's not tough medicine. It's a very simple story. You had a job to do. You correctly identified that this man needed help. You violated your own policy. It looks kind of shady that you have 2 incident reports, but we've got all this evidence showing that you violated the policy. And I knew then that they were going to blame Michael. So I said, let's put this in context. Like, they want to put all of the responsibility on Michael because he was aware enough to ring the bell to say, like, I need help. So he had to have been cognizant enough to understand I shouldn't get up without somebody being there with me. And so I had one rule, and then I had like this word salad of their records, where it is an exhibit like impaired safety. I have it in front of me because I wouldn't remember. Weakness, dizziness, impaired judgment, impulsive, impaired attention, confusion, impaired judgment, impaired balance, all of these things. So like here's this, Goliath with all of these resources, and they want to blame this one guy who is, has all of these things going on in addition to the fact that he can't move. So, we were able to just communicate that the responsibility largely was theirs, and that, shockingly, what I actually thought, Brendan, was that they were going to maybe come in and stipulate to liability and would just be fighting over damages. I was shocked when in the opening, they're like, well, you're going to hear that somebody was by the door. And I'm thinking, oh, this is going to be fun. Can't wait for this. So, my goal was to be quick and be concise and, not overplay the damages. I had a phenomenal treating physician as my expert. So my goal was to be quick, make this simple, and just tell the story that my guy went in with terrible hips, but functioning upper extremities. He came out of there with the inability to use his dominant arm by at least 50%. That's the last thing somebody like him with bilateral lower extremity problems who needed to use a cane or a walker. That's the last thing he needed. And that this is going to be, the way it is for him for the rest of his life.
I mean, that's a very compelling way to present it and think about it. Do you remember generally what your rule was that you used to frame your opening in the case?
Right. Yeah. A level 2 fall risk, should not be requiring bathroom supervision, should not be left alone. And I mean, that I had that question confirmed by 3 of their witnesses. Should a level 2 fall risk ever be left alone in the bathroom? No, arm's length. So I didn't include like the arm's length in my rule, but it was like you should never be left alone.
Well, I think that's okay. So, I recently made probably an error in a med mal in putting a rule together that, had not been so, clearly agreed to, by the defense. And then in turn, you had strong evidence of violating. Okay. And I think that's kind of what was critical there, is that you built your case in discovery, by establishing what was later going to become your rule, and then knowing, or at least later, digging up evidence that overwhelmingly showed that they violated the rule that they said they were required to follow. So that's, and I think another good takeaway is that may not be like your traditional, rule in a sense, but it was perfect for your case.
Right.
I mean, because it's common sense. Everybody agrees to it. You have clear evidence of a violation of it over and over again. So a great way to frame your case. And then here you get sort of an initial gift by finding out in opening
Right.
that they're going to say something that that you can basically, crush. And it's almost just like, boy, I can't wait to see what exactly they try to come up with to recreate history. So can you talk to us about your order of proof? And let me tee it up by saying I unfortunately was out of town, so I couldn't attend some of your trial, but Garrett and Mark from my office, were texting me right afterward and said, oh my God, Sandy played, these videos right off the bat, and it looks so bad for the other side. Can you kind of walk us about, your approach to what you did to kick off your presentation of evidence?
Yeah, sure. So, one of the things that I always like doing, and Vonnie and I, when in our strategy of who's our first witness, and are we going to call people as per cross? Like I think direct exam is the hardest thing of trying a case. Cross is I love cross exam. And then when I, selfishly want to call people as per cross, and I looked at everything that I had in the depositions and the clips, and I thought, why would I take that risk of just anything, of them being able to put in their version of events when I had these great clips and sound bites of everything I needed them to say? So I designated clips from the 3 witnesses I had told you about, the nurse manager, the administrator on duty who was one of the escorts, the patient care tech, and then the corporate designee. And they were quick, and they emphasized everything about the rule, highlighted what best and safe practices are, highlighted all of the things on that word exhibit that Michael had going on in addition to his orthopedic injuries. And importantly, because, by this time I knew it's going to be the patient care technician I will try to be sensitive and say, I couldn't believe they were going to choose that gentleman to be the star of their show and rewriting history. I mean, his deposition was utter disaster. And I bet you Mark was talking about his clips, because literally he would say, like, I didn't know my job title. I don't remember my training. I don't know what a level 1 fall risk is. I don't know what a level 2 risk is. Should I be 6 inches? Should I be 6 feet away? 60 feet away in the hall? I mean, it was like comical. Like he just didn't know what he was doing. And I played those clips not knowing exactly what his testimony was going to be. But so the jury saw, before I called, anyone, what their own witnesses had said. And it was short. I mean, I held myself to the standard of, I'm not going to be wasting time. I'm going to be quick. And I was. So, it was a very short montage of the clips. They counter designated, I think. No, actually, they didn't. They played one of the depositions in their in entirety in their case. But so it was just quick, I thought points that made our case.
From a strategic or presentation standpoint, did you, foreshadow an opening that you were going to lead with, clips of video testimony under oath, or did you more just describe that you're going to hear testimony from X, Y, and Z, and they're going to say this?
I did not say clips. I said you will hear from their own witnesses that the policy is X and they did Y, or they are going to admit this. So I didn't say video clips, but definitely that they would hear from UPMC's own people that they violated the rule.
How many of UPMC's witnesses did you play in clips to open the case? Was it 3?
It was 3, and then I believe before my nurse, I might have done the corporate designee, or maybe used his testimony during her direct. But they saw clips from all 4 of UPMC's witnesses.
And you mentioned this a moment ago, but generally the defense is permitted to counter designate sections of the deposition that they want to be played. So, you say, hey, I highlighted these sections. I'm going to show these to the jury. And typically the defense can say, okay, that's fine, but I want to show these sections. Did they do that at that point or not?
They did send a couple of clips from the patient care technician. They did counter designate a few, but it wasn't, like I said, it was I felt very clean way to get in the points that I was wanting to make had I called them as per cross.
So one thing on that, and I think, you're probably less petty than I am, so you probably didn't do this. But when I get into those situations and the defense says, well, then I want to counter designate X, Y, and Z, like I say, then you got to do it. I'm not putting in your portions of this as if I'm giving this to the jury, because I don't want the jury to think that, I'm supporting this other, part that I don't think is helpful. So I don't know, probably unnecessarily quibbling there.
No, I think that's smart because it shows that that's what they, I guess I could see it 2 ways. That like then you're highlighting that this is what they think is helpful to them as opposed to just running it through. But I see that.
So you kick off that way, and obviously you've got great momentum, it sounds like, with what your clips were. And again, I think, the other big takeaway is just how they appear. Because from what I heard from Garrett and Mark, it was almost not as much as what they were saying. They were just like, oh my God, they just looked so bad. It just looked so bad for the defense, the way them. So I think that's great that you get the kind of double whammy of both the testimony and, just that kind of general appearance and reactions and so forth. Also, don't want to be remiss here. Attorney Drew Rummel helped you without the case, right?
Absolutely, yes. Drew has a medical background, had never tried a case, and was helping me on other matters. And he was like, "Hey, can I, participate or observe?" And I was like, I had gone from trying cases on my own a long time ago at Gizmondi's, but through my time with Vonnie, I always had you had somebody there with you. So I was so happy that he asked, like, hey, can I do this? And I was like, yeah. And so that was nice. Yeah. Drew was a big help.
So take us through, I feel like in most cases when you get a great verdict like this, there are, for lack of a better term, those magic moments or turning points or gifts and so forth. And clearly you kind of knew there was a good chance you were going to get a gift by what the defense was saying in their opening. So, walk us through, you present that testimony, clearly I'm guessing your client does all right. I think you had Glenn Buterbaugh as a great ortho treating doctor, and he's a great witness. But what were the different points in the trial that you really pushed the momentum or took things even to, another level for you to win the case?
Yeah, so starting off with those clips and then going into my nurse expert, and I thought her direct was like not the best, but she really rose to the occasion on cross-examination and did well. And then, in between her and Glenn Buterball, we would do like very quick damage people. And again, like when I say quick, like Brendan, I mean like quick, like less than 10 minutes. And in fact, the last damage witness I called was his sister, and she might have been 5 minutes, but so powerful. And we had, like you said, Glenn Buterball, who is, the treating physician for the Steelers, Penguins, and the Pirates, and the defense like treating him like, terribly and hostilely. And he just is unflappable. He's a gentleman. He just took it in stride and did just a really great job. I mean, he didn't have a dog in this fight. He wasn't testifying in a breach of the standard of care. He was just like, this is how this guy came to me. It was a horrible injury. He's had 3 surgeries. He's going to potentially need a fusion. And so, I thought the case went in, very well.
So what happened on their case? And I mean, typically something good's got to happen in their case too to carry the momentum.
Yeah. So, I mean, I again like couldn't believe their strategy of having this care technician change his testimony. And they had 2 experts. One was a Brotman, Johns Hopkins guy who could not concisely answer a question. And it was maddening. In fact, like I think I might have asked the judge can you please direct him to answer the question, because he would give a speech that was non-responsive. But then I realized he was alienating the jury, and they were just as annoyed with him as I was. But when I pointed out to him, because he was saying at first, he said he disagreed with the arm's length, and they just had to be reasonably accessible. And he would change the standard in each answer. So, I mean, when I pointed out to him, I'm like, well, you've read the depositions of, naming all of the UPMC employees and their designee, who was like their compliance person and safety person, that arm's length is the requirement. Oh, and he was like, he got angry. And I'm like, you're the only person in this courtroom that is like, you're contradicting their own witnesses. Do you not realize that? And then he kind of had this meltdown. And one of the jurors, who ended up being the 4-person, just like laughed out loud. And that was like the only moment where I felt like, okay, they're with us, because they were very stoic, and like, you never know. And I never had this overwhelming feeling like it was, for sure going to be a verdict. But I think that their liability witness was not good. Them calling the patient care technician was disastrous. And then we could talk.
Let's talk about that, because you've touched on that a couple of times. So in his deposition, he knows nothing, like to the extent that he doesn't know the policy, doesn't know the distances, doesn't know his job position, it sounded like doesn't have much of a memory about the event either. So juxtapose that with what did he testify to?
Oh, well, he had been a dedicated patient care technician for several years. He had escorted hundreds, if not thousands, of patients safely to and from the restroom. And he would have remained within arm's length. That was his standard practice, Brendan. And there would be no reason why he wouldn't have done his standard practice on that day. And like, so I'm letting this go on and direct, like she's leading him all over the place. I don't care. I'm just like, I'm not objecting. And I'm just like, this is such a gift. And when I stand up to cross him, the defense counsel's table, if I'm looking at him directly, is to my left. And I kind of stand over to that way. And I was like, Justin, the jury has seen clips of your video deposition. Do you remember the video deposition? And he's like, oh, yeah. And I said, can we agree? And like I had been making a list of things he did not remember as he's testifying. And like, can we agree that you didn't know? And I might have had, I don't even know how many, 5, 10 things. You didn't know this. You didn't. Oh, yeah, yep, that's accurate. And I'm like, but today, and I reiterate some of the things he said. And I'm like, let me guess, sometime between that disastrous depositions and today, you spent a lot of time with your attorneys or UPMC preparing for today. And like he, without even hesitating, he's like, oh yeah, they put me through the training again. And I was like, oh my gosh. Like I just couldn't believe it. And it was very obvious that he was trying hard to remember what he was supposed to say. But like the defense attorney on direct didn't ask him, obviously, the hard question of like, well, if you were there within arm's length, how in the hell did he fall? And why didn't your email say, well, I was there, but unfortunately, which if he was there, that's what he would have written. And I almost felt bad for him because he didn't know what to say. And then he's looking over at counsel and then he was like, oh, delayed reaction time. And I was just like, oh my gosh, like this is just bad. It was bad. It was bad.
Bad, but great.
Bad, but great. Exactly. Because at that point, I think really that was so offensive to the jury. And when people afterward, like I know the defense firm was like, I got calls from several attorneys in there and they're like, how can this be, an arm fracture case for that amount of money? And I'm like, because it wasn't about the arm fracture. I mean, that's the takeaway.
And I think that's the takeaway in a lot of cases is, there are some cases obviously with catastrophic outcomes and so forth, but, on the other hand, the trial is so dynamic. In a lot of instances, it's, jury's just fed up with one side or the other. And, that becomes a multiplier in the verdict. Talk to us a little bit about how you approached closing. Again, doesn't matter. I don't care how mad the jury is, but what were some of the keys in your mind to getting a 7-figure, all non-economic damages verdict in Pennsylvania where you couldn't ask for a specific number?
So the issue of interjecting a number is something that you and I talked about, that I had talked about with the reptile group. Like, how do we do it? And how do we do it without getting a mistrial? And so one of the numbers in the case was, I focused on the training of the patient care technicians and discovered that the overall comprehensive training that you get on fall risks and how to handle them and what a level 1 or a level 2 requires and how you do it was a whopping 30 minutes. And then you're free to go interact with patients. And so there was this, I knew that it was a 30-minute training, which I think is like very underwhelming. And there's no test for proficiency. There's no test for like, hey, does this guy retain and understand it? It's just, we're going to show you a bullet point or whatever it was, and then you're free to go. So I always had 30 minutes to like somehow work into the closing argument. And then we had that fiasco of him changing his testimony and being very well prepared for that. So I was able to like juxtapose, well, hey, I wish UPMC had spent as much time training Justin for his job than they did for his testimony and trial. So I got to like the 30 minutes thing. And then to kind of put a number in their heads. We had had uncontradicted medical testimony about the majority of Michael's, the pain, the suffering, the surgeries, the permanency, with the exception of one issue, one surgery that their expert didn't agree to. But there was like a funny story too about their medical expert that maybe we can chat about. But I had basically uncontradicted medical evidence from Dr. Buterball in our case and Dr. Pollock in their case that this was permanent, and Michael, it's painful. And so from that point of the injury to the trial, it had been like over 2 million minutes of pain. And so when I was talking about like, you've got a very paltry 30 minutes of prep here, and you've got this guy who, because of the lack of training and attention to the job, he's been in pain for 2 million minutes, and that's ticking through every day for the rest of his life. So I thought that was an effective use of, kind of putting a number in. And of course, they moved for a mistrial based on
Well, let's
that.
talk about that. Well, but yeah, what's the basis of the mistrial in that situation, and how did the judge rule?
That I was insinuating a number. I didn't even have to respond. We went to sidebar. They made their motion. The judge said she did not. This is not a like compensation per minute for pain. That is not what she said. That's not, basically. And he looked at me and he said, "Do you have anything to say?" I said, "Other than I adopt your state. For the record, I agree with what Your Honor has said." And that was it. I mean, that was one of their threatened points for post-trial motions. But I knew it was
Well,
going nowhere. Yeah.
I mean, it's really such a ludicrous argument and objection because what what does the jury instruction say? It's you have to account for an amount of money
Right.
for the period of time from the time that this happened up until the present, and then from now until, I mean, it's
It,
literally about time. And, you're combining the time. They just don't like the fact that you broke it down into minutes. But
right.
hey, literally, we live our
By
life minute
minute.
to
Yeah.
minute. And then you put that in context of, I mean, what else are you supposed to do, quite honestly? I mean, for you to do your job of helping this jury, and that's one of the biggest questions they're always having, like, well,
Right.
how how do I quantify it? How do I think about it? And you're, as an effective advocate, you're giving them a sense of, look, don't forget how much time has passed that this guy has lived with
With it.
chronic
Right.
pain.
Right. And I
And
always
you,
say I
jury,
never.
get to do what you want.
Right. And I start like, so when I tried cases, Lonnie and I tried our cases together. She would open, I would always close, and I always pointed out to the jury and explained, like, you're going to wonder, why are we not, explain to them, like, we can't ask for a number, and that's just the constraints that we have. And so and I always explain it in the way of like talking to a jury after they serve and they do an important job. They want to know, like, why didn't you just tell us? And so you kind of explain it, educate them that way, and then figure out a way to sort of drop a number, or address, within the context of the jury charge, which is exactly what you said. And the judge knew it and just, denied their motion.
Well, on that last point of, helping them understand how to do their job, because that's as, important as anything else as, to do their job as a juror is, assuming they get to that question, what is the job entail as far as, coming up, assessing the loss, calculating a number and so forth. And, I think we read all these different, you know, pieces and arguments and books and blogs and so forth about, how to, better convey our client's loss and try to help the jury figure out how to quantify it. And one thing that's kind of crystallized for me lately is in the closing, I literally say, why money? And, you may, whether, you thought about it intentionally or kind of like fluttered through your mind, you may be like at some point wondering, like, why is it money? And you can talk about the Constitution and it's a civil justice system, which I think is really effective. And just telling them, like, that's why we do it. That it's constitutionally based. It's not perfect, but it's the best system that we've come up with. It's the best in the world. And then how much? So then how much, how do you do your job to determine how much? And then you can come up with whatever your, damage model or argument is. And I think you clearly came up with a terrific one. So you close, and then, you never know. But how long were the deliberations, Sandy?
So they were out for maybe like a little over 2 hours. And again, like judging by the team UPMC presence in the courtroom, which they had 3 risk managers there the whole time. They had like a trial tech. They had you know, different attorneys. They had like, the half of the courtroom. And defense counsel, I remember hearing him say, like, they'll be back within 2 hours. And when that in fact happened, there were like fist bumps and like like they were clearly believing, well, this is a defense verdict, which is, that terrible feeling when like there's 20 of them and, they're already celebrating before the jury has come back. I wasn't that concerned because, again, this was not complex. There was not a lot of questions on the verdict slip. But, I did feel like, well, what can you do? You don't know. But I didn't have a great feeling, I'll tell you that. And I never expected the number. But
So how'd it break down?
So when I saw who the foreperson was, I was like, okay, maybe. And then they answered, yes to everything. Even they did like tag my guy with a little bit of contrib because I thought the defense was effective at saying he knew enough to call the call. You know what I mean? Like he knew. I really tried to play that up in closing because I knew that was where I thought like they would be stuck. And I said, hey, if that's what you think, like it should be in comparison to their negligence, then it should be low. But they came back with the 2 lines were going to be past non-economic damages and future. And they said 400 for past, which is what I would have settled the case for. So I was thinking, all right, this is validated, like, hey, I wasn't crazy. And when they said $1 million for future pay, I still don't believe it. As I'm sitting here today, how many, 2 months after the fact or a month and a half after the fact, I still don't believe it. But eternally
What
grateful.
an awesome feeling, right?
Right. And like the difference that will make for my client is just in how incredibly like grateful he is. Like he still texts, like, well, we know each other, but like he can't believe it. And he's like, what can I do to like help you? Like, and I'm like, it's a like, Michael, he's just that thrilled that he couldn't believe it.
That's awesome. To the extent you talked with them or care to share, did you ever talk with any of the jurors afterwards to understand, what struck them, what didn't, and so forth?
So I always handwrite like a thank you note and like a little questionnaire with my email and stuff. And right after I didn't talk to anyone because they are excused and then the judge wanted to talk to us. So like, and they didn't like linger and, but the limited feedback I received was they did not like that the testimony was changed when the written documentation supported what their deposition testimony was. Again, they didn't remember anything, but this is what would have been required. And I think that was why. I think they were like offended that, instead of accepting responsibility, they were willing to kind of be loose with the truth. And that makes sense when you look at the number.
Well, that's awesome. And I'm so happy for you. And I'm so happy for your client, Michael, to, because the guy, he was already going through a tough time. And then, I know he got hit with a little comparative, but mostly through no fault of his own, was left with a life-altering injury that as great as all this is, he still has to live with that forever. And I think sometimes that gets, we lose sight of that because, people are like, oh, big verdict and, and stuff. But, I think that was a terrific outcome. It's a great story. And, kudos to you again, going back to the beginning when it's a friend, reaching out. They had a fall. You're like, I'll help you. We'll probably get this done for something reasonable. And here you wind up on this odyssey, but you see it through. You fight to get the discovery. You get these documents that a lot of, lawyers, because they get preoccupied or distracted, wouldn't have followed up on. And you develop this great case that brings about this great outcome. It doesn't surprise me with you at all, but I'm really happy for you, and I appreciate you coming on and sharing your story about this great verdict, Sandy.
Thanks
For
for having me.
anybody that, well, of course, yeah, no, I'm thrilled, like I said, to have one of my close friends on, and I'm looking forward because we have this group of trial lawyers that are really dedicated to what we do. It's a terrific group. We share so much and get so much out of the group. And I know I'll be interviewing more and more of our friends in the future with great verdicts that they get. But I'm, so fortunate to, to get to learn and bounce ideas off of yourself and all of our friends. So thanks for doing this. Last thing, if anybody, listening, wants to, talk to you, get a copy of any of the, opening or closing if you have it, or, people want to call you about representing them, what's the easiest way for people to get a hold of you, Sandy?
Email or phone. So phone is 412-368-0367, and email ssn@sandraneumanlaw.com, and website if you just Google me. But I appreciate the
Awesome.
plug. Thanks, B.
Oh, 100%. And Sandy's owner of Sandra Neuman Law right here in Pittsburgh, medical malpractice, personal injury. Can't go wrong with Sandy. And Sandy, thanks so much, and appreciate you taking the time to tell us all about this awesome outcome.
It's my pleasure. Thank you, Brendan.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.